Let's come to order and go on the record. Today is September 9th, 2022. The Commission has set this time aside for an on-the-record presentation in the general rate cases of Evergy, Missouri Metro and Evergy, Missouri West, respectively file numbers ending in 0129 and 0130. I would like to note for the record that we were joined earlier by all 5 commissioners, and we currently have Chairman Ryan Silvey and Commissioner Scott Roop on with us, and I am expecting our other commissioners to join us shortly. I do not have a schedule for this presentation. So we'll just follow the order of opening statements as we have been, and I will offer that to the company first. Mr. Fisher, you have the floor.
Well, thank you, Judge. I'm so pleased to announce that we are doing this on the record to talk about 4 different documents that are stipulations and agreements among the parties addressing a wide variety of issues. You asked about how to handle this. You suggested talking about areas we compromised in. I have to say there are so many compromises in this document, and I personally want to thank all the parties for hanging with us for all those late nights where we hammered through these 45 issues or whatever they were that we started with to get down to where a much more manageable number. You know, people talk about state workers. We had state workers that worked long and hard to get us here, so I appreciate that. Anyway, I can go over the documents any way you'd like. The first document is about the revenue requirement issues, and of course the top line issue for us is the agreements on the revenue requirement of $25 million and 42.5 as a starting point for the additional adjustments that are being talked about in the rate case itself and the hearings. You'd mentioned hedging. On page 5, there is a hedging provision. Hedging activity costs and gains will be deferred into the company's regulatory asset liability account for future treatment determination. We can answer other questions about that if you'd like. But perhaps one of the areas that the commissioners might be interested in is the program STIP. It has a number of existing programs that are being improved and some brand new programs that we're going to be instituting. Some of them at the request of the Public Council, like the critical needs and the rehousing program. We're also going to be having a new low-income solar subscription pilot, which is addressed on page 3 of the second stipulation. There's the residential battery energy storage pilot program, which we're looking forward to. And then on page 5 at the bottom, we start talking about non-residential electric vehicles and some of the programs that we're bringing forward there. The business EV charging service is addressed on page 6 of that. I believe that was one that we talked about and got kicked forward to the rate case from the transportation electrification docket that we had. And then there is a separate proposal on class revenue shifts. That was largely adopted among the parties, the customer representatives, and the shifts are actually discussed on page 2 of that one. The fourth stipulation is just one of the standard stipulations that most companies do regarding pensions and OPEBs to get to a starting point for the accounting purposes. But with that, I'm happy to answer your questions, and I'm sure all the parties in this room would be more than happy to give their perspectives. So unless you would like for me to summarize something else, I'd be glad to take those questions.
That sounds excellent, Mr. Fisher. Let's go ahead and get to commissioner questions. Are there any commissioner questions for the company in their opening statement?
No questions at this time, Judge.
Thank you, Chairman. And I also want to recognize for the record that Commissioner Maida Coleman has again joined us for today. The bench does have a question about the hedging.
Okay.
Our How are hedging losses considered under the stipulation? Are they considered costs separately or not at all?
Well, paragraph 3 there on page 5, it says that hedging activity costs and gains will be deferred into the company's regulatory asset liability account for future rate treatment determination. So we're basically deferring those. They used to go through the fuel adjustment clause, but now we're going to have them through a regulatory asset liability account. So
They would be considered as part of the entirety in the
Yeah.
deferred account.
that's correct.
Thank you. I want to follow up on some items of concern to Commissioner Holzman. He had stated he had an interest in voltage, in an voltage optimization study. And the response that Evergy gave was that the issue was settled. Looking over those 4 stipulations, I'm not quite able to locate where that was settled. Can you describe what the settlement was?
It's my understanding from what Kayla Messmore said on the stand that it's not addressed in the settlement. We are doing a number of things that I think Mr. Casely and Kayla Messmore talked about on the record in that area, in that space. And we are looking at those things and doing those studies on our own. They weren't, but they're not a part of the stipulations.
Okay. There were also, under the issue tariff revisions, that's Roman numeral 26,
Yes.
there were A through E sub-issues. I am particularly interested in sub-issue B and C.
Could you give me what those say? I don't have that one in front of me.
B is any changes to be made to Evergy's DER, which is Distributed Energy Resources. Any changes to the DER interconnection tariff was B. C is any changes to be made to Evergy's net metering tariff. The tariff and the stipulation, the stipulation resolves it by stating the signatories accept the company's proposed changes to the market-based demand response program tariff.
Those would be addressed in the testimony of Brad Lutz, and I think that basically we come to an agreement that those suggestions were appropriate.
Were sub-issues B through E then dropped?
Well, in the stipulation, I'm not sure, let's take a look here. On page 13 of the first stipulation, we have general tariff changes. And many of those go to rate design suggestions, I think. I don't see anything on the DER. Counsel, can you help me?
I apologize for interrupting. Nicole Mears with staff. From my understanding, and I believe we have Claire Eubanks who can also help chime in for anything that might go beyond my understanding. But if you look at the first, or what I will call the first stipulation and agreement that resolves the revenue requirement issues, if you turn to page 14, my understanding is that issue, or 7, general tariff changes, under the heading of rate design and program settlement. If you then, which continues on to page 14, that the bullet point D, the company will modify its tariffs to clarify interconnection study terms with staff's proposed language changes and minor cleanup to parallel generation tariff sheets as agreed to by company, and Sir rebuttal involved the proposed discussions and issues with both the DER and net metering. Now, I don't believe that goes to what I've heard in prior cases to the time of use net metering concern, although, and not to get into it because I know that is not resolved, there is questions on if different proposals that are still live may solve that concern, but that part is not addressed. But I think the rest of the issue was supposed to be resolved by D.
And this is my last question. In the company's various SIR rebuttals, they seem to agree to a number of the other parties' recommended changes, mainly staff. But if the stipulation accepts the company's proposed changes, does that mean it rolls back to the company's original position? Or does it incorporate what Evergy said they'd be willing to do in their responses to the other parties in their SIR rebuttal?
I'm not sure which specific ones you're talking about, but I would suggest that the stipulations and agreements that we have agreed to encompass all of the issues, and if it says we go to the company's improvements in the tariff, that's where we would go.
Thank you, sir. I have no other questions.
Thank you.
Let's go to staff.
I will try to keep this short and sweet, and if needed, we have a various group of staff personnel here to try to answer any questions that you may have, and of course I will try to attempt to the best I can. There are 4 stipulations and agreements we are asking you guys to approve in this case. In staff's view, these are just and reasonable agreements that the parties worked very, very hard to come together on and get places that, people gave on certain things to get other things that were priorities to them. So there was a lot of compromise and a lot of discussion and debate to try to come to what we all could agree would be the best outcome for ratepayers. And we believe that the terms in these 4 stipulations would be that. I guess in particular interest to staff, we are happy that we could come to agreement over some reporting requirements for Nucor, as it has been clear that special tariffed rates are becoming more and more interested in by consumers coming to Missouri. So we hope that can help guide future cases and help us get the information we need. The programs, I'll point that step out as an area of great compromise among the parties. Some parties gave a little more to make sure that other parties or other programs they didn't want to see didn't make it in. But I think that we've come to a fair agreement that gives customers some options for renewable and cleaner energy, gives some low-income programs, and helps address concerns for the progression of electric vehicle and electrification in the state. As Mr. Fisher pointed out, the OPEB's pension stip is pretty typical, so I don't think we need to spend much time on that. And then the class revenue allocations, again, driven primarily by the consumer parties, but I think the fact that we were all able to get to a revenue requirement definitely helped make that happen much easier. So I do, again, thank the parties for all working together so we could get a lot of this out of the way.
Thank you. Are there any commissioner questions for staff? And I would also like to remind the commissioners, Brian, if we can get a shot of the courtroom, we have a number of specialized witnesses if any commissioners do have detailed questions that they would like to follow up on. Any commissioner questions for staff? Hearing none. Thank you very much.
Thank you.
I note the attendance of a couple parties, and I'll just go ahead and offer any opening statements from MECG.
I don't have any other comments other than to thank the parties for our agreements and to thank the commission and the presiding officer for allowing us the various delays so that we could reach these settlements. So thank you for that.
Very welcome. I hope that didn't make the video. Nucor, did you wish to make any statements?
No other opening statement except to join in our thanks to the parties, to the commission, to the hearing officer. We did have to adjust a lot of things along the way, and very appreciative that everyone was able to do that. So thank you.
And I believe, subject to correction or a hand raise, that will bring us to the Office of Public Counsel, which will be the last opening statement regarding, or the last presentation regarding these agreements. Mr. Kleiser?
Your Honor, I have no specific opening statements other than to once again echo what other parties have already said, that these agreements represented a result of significant cooperation and time spent by all parties in attempting to negotiate what each party felt was the most reasonable outcome that they could hope to achieve. And I thank the other parties for the efforts that they've put into this and for the commission in making the delays that MECG referenced for allowing these negotiations to continue.
Indeed. I would echo all of those thanks. I would also like to thank the chairman on the record and the commissioners. It is been communicated to those of us who work for the commissioners to make sure and take care of our own health and to take the day out if need be. And without that direction from the chair and the commissioners, I certainly would have been one of those employees who showed up on Friday. So I really appreciate their leadership on that. With all of the thanks being said and done, I'd like to open it up one more time before we get to any final announcements about due dates or anything else we have to discuss. Are there any commissioner comments before we close out this presentation on the 4 stipulations and agreements?
Judge, this is Commissioner Holzman.
Yes, Commissioner, go ahead.
I just want to thank everybody for the diligent process and appreciated better understanding what lays in front of us, and just want to say thank you.
Thank you very much, Commissioner. Okay, let's get to announcements. I would just like to repeat a couple of the items of my understanding. The presiding officer will be submitting late filed Exhibit 1000, which will be the currently effective tariff. Number 2, we will be having Ms. Tucker and Witness Peterson's testimonies refiled in corrected versions with the appropriate reference between, I think what we've all learned is their internal reference to Evergy Metro covering both state jurisdictions. The presiding officer will be issuing shortly, probably not today, a notice of exhibits, and I will include the entirety of the number of exhibits. If you heard my monotone just before lunch, that is, I believe, in the hundreds. I will issue that list. Included with that, I will include the due dates. Late submissions are next Friday, September 16th. And objections will be the Wednesday following, which is the 21st. I will put that in writing for all the parties. Probably not today. I'll try. And that is all the pending announcements I have. Anyone else before we close this proceeding?
Just very briefly, I apologize, I don't have a copy of the filed timeline. Are all the dates still maintained regarding briefing, et cetera?
Yes,
And is there a timeline for transcripts on that?
Yep. September 23rd is the due date for transcripts. And I would like everyone to note that I calculated that well in advance and confirmed that with the court reporter, that is 10 business days after today. Briefs are due October 10th. I am simply restating what is in the procedural schedule, and if I restate it, ignore me and go to the printed schedule. Reply briefs are due October 17th. And our operation of law date is December 6th. Last call, any announcements? Thank you. We are adjourned and off the record.
Thank you, Judge.
Thank you, Judge.
Thank you, Mr. Chairman. Thank you, Commissioner.